Result of the case for Makum PS case 113/2000 forwarded with the FR revealed sufficient material under section 447/294/506/34 IPC. Atrocity IPC read with section 3F 3G 3Q of SC and ST Prevention of Atrocities Act 1989 against the accused petition person Sri Kusumbor Neo, Sanjeev Neo, Sri Tultul Das, and Sri Onil Gogoi, Lakmondan. My lord, the Tultul Das, my lord, he is from SC community, that is Annexure 20. Can you see the Annexure 20 is the, my lord, SC certificate. Now the cognizance was taken by the additional district and session judge in Sukia under section 3F 3G 3Q against one person who is from, he is also from the SC community below. So this is completely ABC the process of law and the act also below. Acts cannot provide the cognizance was taken against the SC person who is belong from the SC community below. What happened in this case, my lord? The 7 complainants filed an FIR against the petitioner while there's
this is a notice will go.
notice
But it has to be seen whether the proceeding under this SC ST Act
no,
can be.
SC not he's I'm just praying for his appearance, my lord. Tultul Das, my lord. He is also from the SC community. SC Act cannot provide that the cognizance was taken against the SC persons, my lord. That is completely abusing the process of law. So, my lord, in this case, my lord, let the record may be called for. In the meantime, my lord, some protection may be given.
After receiving of the record.
No, my lord, otherwise, my lord, 13 February, the 13 of February, the case was fixed, my lord. The adverse order may be given under against the petitioner, my lord. That is why, my lord. Some otherwise, my lord, I have no intention to put seeking any interim, but at least this petitioner may be some protection may be given, my lord. Because this is a completely everything of the process of law. Nowhere stated in the SC Act, your honor. SC Act made only to protect the deprived of the ST community, my lord. Now this person is also belong from the SC community, my lord. He is deprived, man. And the matter is, my lord, twice, my lord, matter was investigated. One, my lord, the police. The charge sheet was filed against the IPC. There is no ingredients found against any SC Act. Thereafter, again, they filed the protest petition, and the petition court issued a fresh investigation. And that investigation, my lord, police.
So you saw the bar in the act itself.
My lord,
You saw the act.
my lord, the act itself says, my lord,
Where? Who is provision? Or it is SC. You saw the provision? SC. Heard, Mr. Your good name?
NC.
Learned counsel for the petitioner, and also heard Ms. A. Begum, learned additional PP for the state respondent. Order dated 6/10/2023, passed by the learned special. No, passed by the learned additional special judge number 2. Within bracket FTC at Tinsukia in special case number 02 within bracket T 2023. Is challenged in this petition under section 482 surface. It is to be noted here that by the impugn order dated so and so, the learned court below has taken cognizance of the offense under section 447, 294, 506, 34 IPC, read with section 3F, 3G, 3Q of SC and ST Prevention of Atrocities Act 1989 against the present petitioner along with one Kusumbar Nauk, Sanjeev Nauk, and Anil Gogoi. The learned counsel for the petitioner submits that the petitioner himself belongs to the SC community, and in support of his contention, the learned counsel for the petitioner has referred to page number
20.
20,
Annexure 1.
Annexure 1 of the petition, which is a certificate issued by Assam Anusuchit Jati Parishad on 23rd/7/1996. And according to the learned counsel for the petitioner, since the petitioner belongs to scheduled caste community, himself belongs to scheduled caste community, he cannot commit the offense under section 3F, 3G, 3Q of the SC and ST Prevention of Atrocities Act 1989. The submission of learned counsel for the petitioner needs further consideration. However, at this stage, let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post and also by usual process upon respondent number respondent number 2, 3, 4, 5, 6, and 7 by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Ms. Ebegam learned additional PP appears and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Having regards to the submission of learned counsel for the petitioner that the petitioner belongs to scheduled caste community and he cannot commit the offense under section 3,
3F, 3Q,
under section 3F, 3B,
3G, 3Q.
3F, 3G, 3Q of SC/ST Prevention Act. This court is of the view that a prima facie case for staying the aforementioned proceeding pending before the Court of Learned Special Judge learned additional special judge number 2 within bracket FTC Tinsukia in special case number 02 within bracket T of 2023 stands state till returnable date. List after 4 weeks.
Much obliged.
Item 18.
Basically, the logic. This is 438 application logic. FIRPZ 8 logic. That is allegation is under section 384 of IPC logic. Page 8 logic. That copy is there.
Is there will be required lordship because there is one line that I have paid her an amount of 7 lakhs. Online transaction.
Let us sit down.
Chief, I will take your lordship to the page number 90 onwards, the WhatsApp conversation which has been attached by the petition informant with the FIR lordship. The conversation between the informant and the petitioner lordship. Kindly come to the page 19 onwards. The WhatsApp conversation. Nowhere it is mentioned that there is a single words by which we can, it is transpired that the petitioner demanded money by putting his hair lordship. There was a relation between the petitioner. and the-
Maybe this may be selective.
I am the landowner, son of the landowner, saying that I am the landowner where garage was situated. And that garage, my lord, owner was Musaddar Ali, who was granted bail. Auto rickshaw owner was Bashir Ali, who was granted bail. And both are died now. And now, my lord, without hearing the informant, my lord, the cognizance is taken against me. So, my lord, in this case now, my lord, now someone is issued.
No,
And
no, how the court below has taken cognizance against you?
this is the reason. My lord. This is also illegal. Because without hearing, my lord, earlier date was fixed for hearing of the
No,
informant.
after completion of investigation, the IO has submitted final report. Thereafter,
There in the year 2019, final report was submitted.
yes.
Now the public prosecutor filed a petition before the learned session judge saying that cognizance may be taken on final report. This is the case.
So who was the informant of this case?
Sub-Inspector Manish Sinha.
So the officer in charge can appear on his behalf.
Yes. But officer in charge were not heard by.
No, he filed a petition.
He did not file petition. Prosecution, public prosecutor filed petition.
Yes, it means the public prosecutor on behalf of the officer in charge has filed a petition.
But informant that sub-inspector was not heard.
Not necessary. Because PT acted on the instruction of the officer in charge. Is it there, Borwa?
So that is, my lord, reflected from the page 21 lordship order.
Acha.
My lord, order, my lord, that is a my lord, petition filed by the public prosecutor lordship paying to take cognizance.
So what is the material against him?
My
Nothing.
lord, he is the owner of the my lord house. Wherein the garage was situated, the owner of the garage is implicated as an accused. Then my lord, the auto rickshaw driver, he has been implicated as an accused, where from this contraband was recovered also. It's a commercial plan, and he is the owner of the property.
Contraband substance was recovered from the garage.
From
Garage.
the auto rickshaw.
Auto
From the
rickshaw.
auto rickshaw.
The
The
auto rickshaw used to.
the
my lord,
auto rickshaw was in the garage.
Was in the garage.
Yes.
I am not the garage owner. Garage owner is some another.
Garage
Who
owner
is
is
operating
somebody else,
garage?
he is the owner of the property. lord.
Property, my lord, where, and my house is not located here. I am the landowner.
So under whose position the garage was?
This is Musaddar Ali, man, another person who was granted.
Then,
additional-
as per prosecution,
My lord,
It is mentioned in the order also.
Mohammed Musaddar Ali lordship.
Masaddar Ali. So if the garage was in the possession of that person, how can you implicate this present applicant?
It is not, question is that Lordship, he has not challenged this order, Lordship, 2/7/2022. Now, Lordship, the trial court has issued someone, but he is apprehending, probably he is apprehending, and that is why he is not appearing. Trial court has not issued any warrant, Lordship. Only someone is issued, Lordship. Only the question is that it's a commercial quantity Lordship, which was recovered. And there is no mention in the amount of searches, my lord, against his implication. Lordship.
Against his,
Yes, Lordship, I have.
against the
whatever-
material available against him.
my lord. And other two persons, Lordship, they died. Very peculiar circumstances, Lordship.
I mean, as a totally innocent person, I don't know even anything regarding where the auto is staying. Now in the year, after 10 years, my lord, someone is, and earlier, never I was called for any witness, nothing.
Why don't you challenge the order of taking cognizance by the learned court below?
That
At
he
this
should have
time,
not have challenged,
I
Lordship.
will challenge my lord, at this stage, my lord, under protection may be granted under
No,
438.
protection means, you see, this is the contraband substance was a commercial quantity. Then you have to face the level of scrutiny in case of of section 37.
So, my lord, I will appear, my lord, if
Hmm.
there is necessity, I will challenge this order. And if
Mhm.
there is necessity, but still, my lord, now under this petition under 438, my lord. So now, my lord, on appearance, my lord, that-
No, in case of 438, that embargo is there. But in case of
37.
this 482 petition, it can be challenged. The maintainability of the order.
He should have challenged that order, Lordship.
Sir, my lord,
So anyway, heard me, sir.
H. Arjun.
Sir Sodore, learned counsel for the applicant, and Mr. Arjay Bora, learned additional PP for the state respondent. Argument concluded, order is that
47.
Mr. Sodore, even if we grant you the privilege of peerless bail, then also it will be till your appearance before the court below. But ultimately, you will get nothing. Once you appear before the court below, court may remand you to jail. That is the discretion of the court. So in that case, you have to challenge the order
Yes, ma'am, right,
as early as possible.
Item 47.
My lordship, 438 application, my lord, he was called for, my lord. I am not in interim, my lord.
Yes,
lord.
law court, you received the case again?
Lordship, I have received. My lord, in the meantime, we have received the 41 notice, my lord. I have received whereby I was called to appear before the
That's
Iowa.
all right.
My lord,
So what is your case?
My lord, FIR is page number 18, my lord. FIR is 18. So many allegations, all are documentary evidence. I have sufficient documents to reply that. Already I replied, my lord, already I appeared before the IO on 5/2. And he recorded my statement and he released me, my lord.
So pursuant to the 41 notice.
My lord. It is the notice, my lord.
Yes, Mr. Lockwood, if the 41 notice has been served
Served,
upon
he
him
appeared
and he
also, he-
appeared before the IO,
He appeared, Lordship. His
Then-
statement has been recorded, Lordship.
then
And Lordship, here, Lordship, he has stated everything, Lordship, how, and as per his statement, Lordship, it seems that, Lordship, he has done whatever he has done, Lordship, as per the bylaws, as per his statement, Lordship. This, Lordship.
so what is the allegation?
My lord, the allegation, my lord, already specifically stated in my petition, my lord, page number 4, my lord. So many allegations, my lord.
No, you come to the Azahar.
My lord.
Azahar is at page number 18.
Page number 18, my lord. Page number 18.
My lord, married, my lord.
No, where is the substance?
My lord, page number 19, my lord.
Hmm.
Page number 19, my lord. Hide instruction and head transfer sum of rupees 9 lakhs. 9 lakhs out of 9 lakhs 20,000, my lord, which is funds raised particularly for the maintenance and keep the permissions of the church to the accounts of the Diocese of the Northeast India in Shillong, of which is the head of the thereof. It is transferred from account transferred from Guwahati to Shillong. My lord, this is the one allegation. And another allegation, my lord, second paragraph, my lord. Further, his unlawful activities and gross anomalies are not only confined to Guwahati but also being carried out to Tezpur and Dibrugarh. The diocese has a school at Tezpur, namely All Saints High School, Tezpur. In addition, the diocese possesses a plot of land in the area under its management for which a trust, namely the Northeast India Diocese Trust Association, has been created for the management of the lands, and it had to the Bishop Michael Herens by its ex officio position. A portion of the said land has been mortgaged to the HDFC Bank and the money has been deposited in the school account fund. This specifically mentions, my lord. And already we have replied in my statement, my lord. The already fund has been used for the school's management on, and another amount has been fixed deposit. Already I have exhibited, my lord, the certificate, my lord, page number 27. Page number 27, my lord.
Okay, heard Mr. Your good name,
R. Purva, my lord.
learned counsel for the applicant, and also heard Mr. E.S. Locker, learned additional KP for the state respondent. Appearing arrest in connection with Panbazar PS case number 271 of 2023 under section 406 part 20 IPC. This application under section 438 service is prepared by applicant Michael Herens for grant of previous bail. The above noted case has been registered on the basis of one FIR lodged by one Tridip Sunni Musahare. The essence of allegation made in the FIR dated so and so is that the applicant, namely Michael Herens, has transferred a sum of rupees 9 lakhs where he has transferred the amount.
My lord, from Guwahati, Guwahati search account to Shillong. Shillong search account, my lord. Diocese to the central fund, my lord, which is situated at Tezpur, my lord.
To the account of Diocese of Northeast India, Shillong. Of which he is the head. And also indulge in some unlawful activities. And he created a trust, namely Northeast India Diocese Trust Association, and mortgaged a portion of the land to HDFC Bank. And deposited the money in the school account fund. And also transferred a sum of rupees 75 lakhs from the school in Tezpur to Northeast India Diocese Trust Association, Shillong. And withdrawn another sum of rupees 1 crore 6 lakhs for unknown purposes. Mr. Borwa Learned Counsel for the applicant submits that the applicant has received notice under section 41 ACRPC. And pursuant to the said notice, he had appeared before the IO when he has been appeared before the IO on 5/2.
My lord.
5/2/2024, and he has been cooperating with the investigating agency. And therefore, Mr. Borwa contended that the privilege of entering on the privilege of previous bail may be extended to the applicant. Whereas Mr. P.S. Lokor, learned additional PP, has produced the case diary before this court and submits that the IO has collected some materials in support of the allegation made in the FIR. However, Mr. Lokor confirmed that pursuant to notice under section 41A CRPC, the applicant had appeared before the IO and cooperating with the investigating agency. But in view of the materials that having heard the submission. In view of the materials collected so far in the case diary, and also in view of the cooperation being extended by the applicant to the investigating agency, this court is inclined to, no, this court is of the view that custodial interrogation of the applicant may not be required in the interest of investigation, and accordingly, this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with Panbazar PS case number so under section so, he shall be released on interim period bail on his executing a bond of rupees 50,000 with 1 surety of like amount to the satisfaction of the arresting authority. Therefore, privilege is however subject to the following 3 conditions. Last condition is shall not leave the jurisdiction of CJM Kamrup M without prior permission. In terms of this heavy sensitivity of city related.
Keep reply.
57.
Facts, therefore, Lord, the lordship will kindly have a look at the order passed. My lord, order, lordship is page 26. They have made a statement, a submission that confiscation proceeding has been initiated. And therefore, lordship, therefore, by private satisfaction, they have passed an interim order. But my lord, the fact remains that after filing of the petition, my lord, they have now issued a notice, my lord, that is, of the petition is filed on 13/6/2023. And now, after filing on, my lord, on 14/7, they have initiated the process. That I have annexed, my lord, 56 page. In my, so, my lord, this has to go, and the order passed by the learned magistrate, my lord, based on the order passed by the initial district judge, my lord, who said, who on, my lord, going to the record said no confiscation was initiated. The order put to challenge, my lord, will kindly have a look at page 33, which was put to challenge before lordship, as page 33.
And start question. Start. I got it.
Lordship got page 33, my lord. This order, page 33 of my IA. Lordship got it.
Yes.
This order says, seen the order dated 24/3/2023, that is at page 29, I'll take the lordship a little later. Passed by the criminal division whereby the honorable court has observed, nothing has been mentioned about the confiscation proceeding of the seized JCB bearing registration number so and so. As such, the honorable court has given the petitioner liberty to approach the court seeking Jimma of the seized JCB, and in the event of filing such petition, the court is to consider in accordance with law. And thereafter, my lord, I filed the petition. The original order, my lord, will kindly have a look at page 29. Page 29. On the basis of which the court has passed the order. Page 29. Lordship got it. The last para, since as it appears from the offence report that nothing has been mentioned about initiation of confiscation proceeding, the petitioner hereby may approach the landed court below seeking Jimma of the seized JCB, and in the event of filing such petition of Jimma, the landed trial court may consider the same in accordance with law. That is how the order is passed. Now, my lord, will kindly have a look at page 56. Absolutely, my lord. This time, my lord, this order is on 14/7. The criminal petition is filed before this court on 13/6/2023. And making a statement, they have initiated the confiscation. They have now, after filing, they have initiated here
No,
for the first time. And this order is put to challenge again. And this is stated by the learned regent. This lodge will find at page 58. 58 and 59 is the relevant part. So, my lord, all incorrect facts. By taking resort to section 49(5), my lord, they can initiate the process. There are decisions of this honorable court. Not prior to that. No notice was issued to me ever before 14/7. This is for the first time they've initiated 14/7. After filing the criminal petition. Criminal petition is filed before this court on 13/6. I've checked up. They have not moved for so many months and moved it after this. So apparently, my lord, this is-
No, the additional session judge has directed the court below to consider the Zimma petition in accordance with
that
law.
considered the petition and
And
granted the
the magistrate has considered it and directed to release the vehicle.
lordship.
Thereafter,
Thereafter, my lord, they have filed this petition, my lord. They have filed this petition before this court on 13/6/2023.
hmm,
And after that only on 14/7, they've initiated the process. By saying before this court that they've initiated the process, admitted position is they did not till the order passed by the magistrate and the session judge, the additional district judge. So apparently, my lord, this has to go. All wrong facts placed before this order. And your lordship was influenced by their statement made. My lord will kindly have a look at their petition at para 3. Without para 3, the lordship will for a while take up their petition.
no, in the order dated 28/8/2023,
Yes.
they have not made any statement that a confiscation proceeding has been.
Petition the lordship, because the lordship will kindly have the look at the petition.
Hmm.
Their petition, they have said, para 3. Their petition, the lordship take up. And based on this, the lordship will not definitely, unless the confiscation proceeding initiated, they cannot, my lord. And lordship will kindly have a look at para 3 of their petition, paragraph 3 at page 3.
Hmm.
It says that in the meantime, after prima facie satisfied offense, the divisional forester become authorized officer, Dick Boyd, has passed an order initiating confiscation proceeding. So my humble submission, lordship will, it's so many months now. More than, it was in December. My vehicle is, my lord, I am out of, I'm in any vocation, my lord, now. There are all statements, they have not said, they have only said initiated proceedings. And your lordship, if the proceedings are initiated, then your lordship would have been right, my lord. So admitted position is, my lord, since 14/7 is, I have placed.
Yes, Mr. Gogoi,
My
when
lord,
it was started.
My lord, this I can clarify, my lord. I stand by my statement, my lord. Before, my lord, this order was given by the Zimma court to give Zimma, my lord, confiscation proceeding was initiated.
So why this 14/7?
No, my lord, before that was initiated, my lord. No, I'm on oath, my lord. Just, I will file written, my lord, I'll file an additional affidavit bringing on that record, my lord. That will file, my lord. And that apart, my lord, that apart, my lord, see kindly at page 13, my lord. Page 13. The paragraph, my lord, considering the documents and taking into note the order of the Honorable Appellate Court, I deem it fit to allow the play of the petitioner. Where is the consideration? The Appellate Court said, event of the filing under Zimma may consider same in accordance with law. Nothing was discussed. Where is the law? Nothing has come. Who did it? What did it? Nothing was given. Only, my lord, relying on that, relying because, my lord, what happened, the learned JMFC, earlier she has rejected. When the respondent moved to the appellate court gave an observation, nothing on merits.
You have not challenged the decision order of your own. You have not challenged that.
I have challenged that
No, that we are not challenging because that was not on merit. It said.
No, now you produce
Now,
the
my lord, I
document.
can- I
No,
could-
Mr. Gogoi.
my lord, given a week, I can come, not given a week also, my lord, last 2-3 days I can, next week it can be fixed, my lord, I can
Okay,
bring all the
okay.
case records.
On the pair being made by
Well-
Mr. D. Gogoi, Learned Standing Counsel for the Forest Department. Rest shall raise the matter on Monday.
On Thursday, Lord, 15.
15.
Few lesser cases.
15.
15. I'll call the case records, my lord, if I don't find anything, my lords, I'll apologize and withdraw this. But
Okay.
I'm very true, my lord, it was
This is a,
indicated
this is
before
a,
that.
this is
So
rather
as
the,
to enable him to produce the proceeding relating to confiscation of the seized vehicle.
Yes, my lord.
this is a fair statement made by my learned friend.
Yes, yes.
53.
All is well.
May it please your lordship. Lordship, this is an interlocutory application for modification of a bail order, lordship, dated 13/9/21. Lordship, to issue a small lordship in the bail order, which is at page number 16, my lord. The order starts at page number 10, my lord. Order starts at page number 10. The case where, my lord, the accused was arrested in a birthday party, my lord. At that time, COVID was going on, and when some other person, lordship, some
Yes,
contraband was
Mr.
also.
Sharma.
My lord.
And lordship, the condition which I seek, lordship, to be modified,
So
In
what
the
do you
page
want
16.
here?
page number 16, lordship.
Hmm.
Page number 16, condition B, my lord. Condition A is already there, that I will not leave the territorial jurisdiction without prior permission. Let that be there, lordship. Condition B, my lord, shall deposit his passport in the court of learned special judge. Lordship, I have regular electronic vehicle meetings in Thailand and other South Asian countries. 2 invitations I have missed only, lordship. Those pages I have annexed, my lord. Page number 18 and 19, my lord. Those are invitations I could not go before because my passport is with Learned Additional District Judge number 5. My tickets were also done, my lord, by the organizers. But I could not avail because
So,
the passport-
Mr. Sharma,
My lord.
by obtaining permission from the court below, he can visit the
Oh.
countries
yes, my lord.
which he desires to visit.
That I feel, but the passport, lordship, the lower court is of the opinion, lordship, the passport, because the high court has directed the passport to be deposited.
Hmm.
So this condition has to be moved. Accordingly, lordship may see at page number 22 and 24, the prime accused has also approached this court, lordship, and taking this view that permission, of course, the accused person will take from the trial court, but passport, lordship, because in certain countries we have to submit the passport way ahead, lordship, in the embassy before taking permission also. So this prime accused in whose house the incident happened, this was allowed.
Okay.
Other accused also.
Heard Mr. D.K. Bodya, Learned Counsel for the applicant, and also heard Mr. B. Sharma, Learned Additional PP for the state respondent. This interlocutory application is preferred by the applicant for relaxation stroke modification of the bail order dated 13/7/2021, passed in BA number 2185 of 2021, within bracket Hirendo Sinha versus State of Assam. Mr. Bodya, Learned Counsel for the applicant, submits that the applicant was arrested in connection with NDPS case number 151 of 2021 under section 188, 120B, 269, 270 IPC. Read with section 20 within bracket A stroke 21 within bracket B, 25 and 29 of the NDPS Act. Read with section 67 of the IT Act and section 4 and 5 of the Assam Bhang and Ganja Prohibition Act. And he was granted bail by this court by order dated 13/9/2021 in BA number 2185/2021, imposing some conditions which are extracted herein below.
Paragraph 11.
Mr. Bodya further submits that one of the condition is that the applicant shall deposit his passport, stroke visa, etc., if any, in the court of learned jurisdictional special judge. And pursuant to the said order, the applicant has deposited his passport, stroke visa, etc. with the Court of Learned Jurisdictional Special Judge. Mr. Vaidya further submits that the applicant is a businessman dealing with the business of
Lordship, electronic vehicles. my lord.
electronic vehicles, and he has to visit the South Asian countries from time to time. And because of this condition, he could not visit the states, visit the countries in respect of his, for the purpose of his business. And therefore, it is submitted that the aforementioned condition may be relaxed and the passport may be released, and with permission of the learned special judge, jurisdictional special judge, the applicant may be allowed to visit the countries for his business purpose. Mr. B. Sharma, learned additional PP, submits that he has no objection in the event of modifying the aforesaid condition.
But he has to follow the other conditions, bail
Right.
conditions.
Yes.
Provided the applicant follows the other condition imposed by this court
At the time of granting bail.
at the time of,
Granting bail, man.
that has already been. But having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also peruse the impugn or also peruse the conditions imposed by order dated 13/9/2021. It appears that in condition number B, it has been provided that the applicant shall deposit his passport, visa, etc. with the Court of Learned Jurisdictional Special Judge. At what stage the case is pending?
Lordship, copy, lordship. Copy is being served to the accused. Appearance and copy.
It is submitted. No, Mr. Boydya, Learned Counsel for the applicant further submits that the case is pending for furnishing copies under section 207 of the CRPC. And that the applicant will appear before, the applicant will abide by rest of the conditions. And under such assurance, this court is inclined to allow this application by modifying the order, modifying the condition number B to the extent that the learned court below shall release the passport stroke visa in favor of the applicant, and he may be permitted to visit the countries he desires to visit for his business purpose. কি কোনো last order ito?
The applicant may be permitted to visit the countries
Which he desires to visit.
which he desires to visit
Mm,
for his business purpose.
Business purpose. In terms of above this, I instance this program.